On the very last day of its term, the Supreme Court made 3 moves in a single morning, and each one lands differently on the millions of gun owners living in California. One case was accepted, several were turned away, and one, the case Californians have been watching most anxiously of all, was quietly pushed into limbo for yet another season. If you own firearms in the Golden State, or you're simply trying to understand where the biggest constitutional fight in the country is headed, what happened on that final day is going to shape the next 12 months of your legal reality. And the most important part is the piece almost everyone is misreading. Start with the case the court accepted, because everything else flows from it. The justices granted review in 2 challenges at once, one against Cook County, Illinois, home of Chicago, and one against Connecticut, and consolidated them into a single case that will now carry one name going forward. The question they agreed to answer is as direct as it gets. Do the 2nd and 14th Amendments guarantee the right to possess AR-15 platform and similar semi-automatic rifles? This is what court watchers call a hardware case, a case about the guns themselves rather than who may carry them or where. And here's why that word matters so much. In the 18 years since the court first recognized an individual right to keep a handgun in the home, it has never once directly ruled on whether a specific type of firearm can be banned. Carry rules, yes. Permit schemes, yes. The actual hardware, never. Until now. Plenty of people were surprised the court took the case at all, but the surprise fades once you remember a simple piece of Supreme Court mechanics. It takes only 4 votes to grant review, and at least 4 justices have been signaling for over a year, in published dissents and statements, that they believe lower courts have been mishandling this exact question. One justice even predicted in writing a year ago that the court would take up the issue within a term or 2, and specifically named the Illinois case as one worth waiting for. So this was not an impulse. It was a slow, deliberate setup finally reaching its moment. Now, to understand what the court will actually decide, you need one piece of legal machinery, and it is worth 30 seconds because it explains everything that follows under the controlling framework. Every Second Amendment case runs through a 2-step test. Step 1 asks whether the plain text of the amendment covers the conduct at issue, which turns on whether the item in question counts as an arm. If it does, Step 2 shifts the burden onto the government. The government must prove its law is consistent with historically analogous regulations from the founding era, or possibly the Reconstruction era, a time frame question the court has never fully resolved. The single most important question inside Step 1 is whether the weapon is in common use by law-abiding citizens. And this is where the challengers believe the math is simply unavoidable. These rifles are among the most widely owned firearms in the entire country, numbering in the tens of millions, legal in roughly 40 states. Their argument is that something that common cannot be called unusual and cannot be written out of the word arms. The other side, it must be said, is not conceding an inch. The officials defending these bans argue that these rifles are materially similar to military weapons the court itself has said can be regulated. They point to the devastating role these firearms have played in many of the nation's deadliest mass shootings, including one inside Cook County itself, where a gunman fired 83 rounds into a holiday parade in under a minute. Gun safety organizations called the court's decision to hear the challenge reckless, and they have one undeniably powerful fact on their side. Every single federal appeals court to rule on these bans has upheld them. There's no split in outcomes anywhere in the country, which makes the court's decision to step in anyway all the more loaded, because you generally do not reach down to bless a unanimous consensus. Advocates on the gun rights side are openly predicting the bans fall in a 6-3 decision. The defenders are betting the court blinks at the prospect of unwinding a dozen states' laws. Nobody actually knows, and the 2 justices considered most likely to decide it, the Chief Justice and one of the court's newer members, have kept their cards face down. Here is where California enters the picture directly, and this is the connection that turns a Midwest and New England case into a Golden State earthquake. California has its own ban on these rifles and its own long-running challenge, a case called Miller versus Bonta, which is currently sitting in the Ninth Circuit. Whatever the Supreme Court decides, in the consolidated case will be binding on every court in the country, including the Ninth Circuit. In practical terms, the ruling will very likely be dispositive of the California case, meaning Miller will rise or fall on a decision made about Illinois and Connecticut laws. Californians will get their answer without their own case ever reaching Washington. Oral argument is expected in the fall, and while a decision could theoretically come as early as December, The realistic timeline for a ruling of this magnitude is next June, roughly 1 year out. Now for the case the court did not decide, and this is the one with the most immediate practical consequence for California gun owners. The state's ban on magazines holding more than 10 rounds has been challenged in a case called Duncan versus Bonta, and a parallel Washington state case has been riding alongside it. All term long, the justices have relisted these cases, conference after conference, week after week, never granting and never denying. On the final day, they did it one more time. The magazine cases were carried over to the next term, with the first conference expected in late September. That sounds like a non-event, but read it carefully because the details matter enormously. As long as the case remains pending at the Supreme Court, the current legal status quo holds magazines that were lawfully acquired, including during the brief 2019 window California owners famously call Freedom Week, remain legal to possess. Nothing changed. No deadline arrived. The can was kicked, and for owners, the kick preserved the protection. So why hold the magazine cases instead of just deciding them? This is where a piece of insider vocabulary explains the court's likely strategy. GVR, which stands for grant, vacate, and remand. It is the move the court uses when it wants a lower court to redo its work in light of a new precedent without writing a full opinion itself. The widely expected play is this. The court decides the big rifle case next June, sets down a nationwide rule about what counts as an arm and how the common use test works, and then GVRs the magazine cases, wiping out the lower court rulings and ordering them redone under the new standard. The court has already done exactly this once before in the Duncan saga, sending it back after a previous landmark decision. Whether the Ninth Circuit takes the hint the second time is, as they say, another question entirely. And there is one more possibility worth flagging. The justices could write the rifle opinion broadly enough to drop language that effectively resolves the magazine question too, settling both fights with one pen. The court also quietly closed a door on the same day. It denied review in several cases challenging restrictions on 18 to 20-year-olds buying and carrying firearms. Even though the appeals courts are genuinely split on that question, only one justice noted he would have taken one of them. The message seems clear. The court has bandwidth for one blockbuster Second Amendment question per term, and it chose the rifles. Zoom out. And the term that just ended was a remarkably consequential one for this area of law. In its final weeks, the court struck down Hawaii's rule requiring gun owners to get a property owner's express permission before carrying into private businesses open to the public. It also limited the government's ability to prosecute people for gun possession merely because they occasionally use marijuana. That first ruling has direct California implications too. A challenge to California's own list of so-called sensitive places, called May versus Bonta, is expected to restart in the Ninth Circuit with fresh ammunition from the Hawaii decision. And in a final twist landing just one day after the court's announcements, the federal government itself jumped into the fight. It filed lawsuits against California and Virginia seeking to block their rifle bans, an extraordinary escalation timed almost to the hour with the Supreme Court's grant. So here's the bottom line. The Supreme Court will finally answer whether the most commonly owned rifle in America is constitutionally protected, with arguments this fall and a likely ruling next June. That single decision will effectively decide California's own ban through the Miller case. The magazine question is paused, not lost, and lawfully acquired magazines remain legal in California while it waits. The young adult cases are off the table for now, and a term that began quietly ended with the most consequential Second Amendment docket in a generation, with California sitting closer to the blast radius than almost any state in the country. Whatever happens next June, the rules in the Golden State will not look the same the day after. That's it for today, folks. See you in the next video.